Good morning, everyone. Today's topic is business forms and legislation and MPC 13 Business Law, block number 2. Under this block, we will cover the Partnership Act 1932 as well as the Companies Act 2013. In today's lecture, today's session, we will take Partnership Act 1932. The Partnership Act 1932, first of all, object. The completion of studying this unit, you will be, being as a student, you will be able to define partnership and the explanation its essential features, describe different type of partners and the partnerships, differentiate between partnership and other form of organization, business organizations, how registration of the partnership firm can be done, explain the circumstances when partnership is reconstituted and the firm is dissolved. First of all, we have to discuss about the structure, introduction, nature of partnership, definition of partnership, and within partnership, what is the definition of partner, firm, and the firm's name. Essentials, elements, and the essential of partnership, type of partnership, position of minor as a partner, type of partnership, distinguished from other kind of business organization, formation of registration of partnership, formation of partnership, partnership deed. This formation of deed is very important because the partnership is a contract amongst a partner, between or amongst a partner, and it is a agreement. Registration of partnership, effect of non-registration of partnership, relation of partners to one another, and appreciate the meaning of term limited liability partnership. This is the whole concept under the banner of partnership. This is a LLP. Uh, Scope and advantage of incorporation of LLP. So, when we talk about the structure, introduction, nature of partnership, definition of partnership, essential of partnership, type of partners, position as a minor as a partner, type of partnership, partnership distinguished from the other business organizations. So first of all, we have to take after rest of the thing, the right of partners, duties of partners, relation of the partners to the third parties, partners as an agent, and authority of partners, reconstitution of firms. In this particular thing, we have to discuss and try to understand what are the situation when we have to reconstitute the firms or firms agreement. Admission of new partner and the retirement of the partner, expulsion of the partner, death and insolvency of partner. And at the end, what are the basic parameters and the situation when we can go for the dissolution of the partnership. Limited Liability Partnership Act 2008. This is the new concept under the partnership, and the difference between other forms of organization and the LLP, advantage and the disadvantage of limited liability partnership, and how we can go ahead for the incorporation of LLP. First of all, we have to go for the introduction of the partnership. The development of the business and the growth in business transactions lead to the replacement of the proprietary form or proprietor business of business organization with the partnership enterprises. Partnership is a form of business organization where two or more persons come together with jointly carrying on the some business. In partnership, two or more persons pool their resources, both money as well as material, to their mutual advantage and thus share the business risk too. Initially, the Indian Contract Act 1872 governed all aspects of commerce and the trade under Chapter 9, Section 2039 to 266 of this particular act, which is regulate or control the partnership business. A need for more specific governance, and the government took step to legislate further. Chapter 9 and Section 239 to 266 are replaced by Indian Partnership Act 1932. Partnership is mere a voluntary collective and has no force of law to its constitution. A partnership arises from a contract, and therefore such a contract is governed not only by the provision of the Partnership Act in that regard, but also by the general law of contract in such matter, where the Partnership Act does not specifically make any provision. Thus, the rules relating to offer and acceptance, consideration, free consent, and legality of the object, etc. These are the essential features of the partnership, as contained in the Indian Contract Act, are applicable to the contract of partnership also. Nature of partnership. Definition of partnership is a partner, firm, and the firm names. Section 4 of Indian Partnership Act 1932 laid down the definition of partnership, partner, firm, and the firm name. Under the head of partnership, partnership is the relationship between persons who have agreed to share the profits of the business carried on by all or any of them acting for all. There are three aspects of partnership, partner, firm, and the firm name. Persons who have entered into partnership with one another are called individually partners and collectively a firm. And in the name of under which the business is carried on is called the firm's name. Essential of partnership. The examination of the definition of partnership given in the section 4 of the Act indicates that the following elements must coexist before a partnership can come into existence. There must be minimum two partners. The relationship must arise out of the agreement between two or more persons to carry on the business. The agreement must be share the profit of the business. The business must be carried on by all or any of them acting for all. Each partner is liable for all the acts of the firm done by the partner. We shall now discuss the aforesaid elements briefly. Association of two or more persons. In order to form a partnership, there must be a contract between two or more persons coming together for a common goal. Person must be competent to enter into a contract. They may all be natural or artificial, or some natural and other artificial. Agreement. According to Section 5, the relation of partnership arises from the contract and not from status. Thus, the member of HUF, Hindu Undivided Family, carrying on the family business, or the Brahmins Buddhist husband and wife carrying on the business, are not partners. In such business, the agreement is the basis of relationship between a partner. Business. The agreement should be carry on some lawful business or the business activities. Sharing of profit. To constitute a partnership, the parties must have agreed to carry on a business, not a charitable activity, and to share profit in common. Unless otherwise agreed share, a profit also involves sharing of losses as well. Mutual agency. Each partner carrying on the business is the principal as well as the agent for all the other partners. He can bind other partners by his act and also be bound by the act of other partners with regard to business of the firm. Liability of the partners. Each partner is liable jointly and severally to the third party for all the acts of the firm done while he is a partner. The liability of the partner for act of the firm is unlimited. The partner's private assets can also be used for paying off the firm's debt. Now we'll come to the types of partner. There are basically two categories of the partners: partners by virtue of partnership agreement and partners by virtue of holding on. The Act does not provide about the types of partner. This is decided on the partnership contract. In practice, based on the extent of liability, the different classes of partners are actual, active, partner. Such a partner actively participates in the function and the management of the business and share its profit or losses. This is a common type of partner. The another one is the sleeping or the dormant partners. These partners invest money in the firm business and share profit but do not participate in the functioning and the management of the business. The next one is a nominal partner. Such a partner neither invites nor participates in the management of the firm but only gives his name to the business or the firm. Partners in profit only. A partner who is entitled to share in the profits of a partnership firm without being liable to share the losses is called the partner in profits only. The next category of the partner is a sub-partner, where a partner agrees to share his profit in the firm with a third person, and the third person is called a sub-partner. A sub-partner is not the partner of the firm in actual manner. He is a partner of a partner. A sub-partner has no right and duties towards the firm and does not carry any kind of liability for the debt of the firm. Firm partner by estoppel or by holding out. If the person by his act or the word gives another person reason to believe that he is a partner in a firm when actually he is not, and that other person takes action on those set of facts, such a person is estoppel uh, from later on denying the liability for the act of the firm. Thus, it is a legally binding partnership that may occur where previously, no former partnership agreement was in place. Such person is called partner by estoppel and is liable to all third parties. Similarly, when the firm declare a person to be a partner, when actually he is not, and that person knowingly permits himself to be representative, to be a partner in a firm, and does not deny the fact that he is a partner, then such a person is known as a partner by holding out. An active partner who's failed to give public notice at the time of a retirement is also liable as a partner by holding out. In the case of minor, position of minor as a partner, minor admitted to the benefit of the partnership. Since the partnership is a contractual relationship, the parties to contract must be competent to contract under the law to which they are subject. A minor is incompetent to contract. Hence, he cannot become a partner, but with the consent of all the partners, he may be admitted to the benefit of the partnership. In that case, the right of the minor, he is entitled to share of the property and the profit of the firms as agreed upon. He can have access to and inspect the copy of any documents, accounts of the firm, but not any other books. A minor can sue a partners for an account or the payment of his share of the property or the profit of the firm. Liabilities of the minor. A minor is liable to the extent of his share in the firm. He is neither personally liable nor is his private estate liable for the act of the firm. He cannot be declared insolvent if the firm debt cannot be paid out of the firm's property or assets. Position on attending majority. When a minor has a choice of become a partner or sever his connection from the firm within 6 months of his attaining the age of maturity, or when he comes to know of his being admitted to the benefit of the partnership, whichever the date is later. Where such person become a partner, his right and liabilities as a minor continue up to the date on which he become a partner. He also become a personally liable to the third parties for all acts of the firm done since he was admitted to a benefit of the partnership, and his share in the property and the profit of the firm shall be the share to which he was entitled as a minor. Where such person elect not to become a partner, his right and the liability shall continue to be those of the minor under this section up to the date on which he gives public notice. His share shall not be liable for any act of the firm done after the date of such notice, and he shall be entitled to sue partners for the shares of property and the profit. Now we'll come to various types of partnership. A partnership may be for a particular adventure or for a fixed period or at will. From the duration point of view, the partnership may be classified into the following two. Partnership at will. According to Section 7 of this Act, partnership is at will when no fixed period has been agreed upon for the duration of the partnership, and there is no provision made as such to the determination of the partnership in any other way. The death or the retirement of the partner does not affect the existence of such partnership, as there is no fixed or the definite date of termination. Such a partnership can be dissolved by any partner giving a written notice to the rest of the other partners of his intention to dissolve the firm under Section 43, subsection 1. The firm is dissolved from the date mentioned in the notice as the date of dissolution, or if no such date is mentioned, as from the date of communication of the notice of dissolution. Hindu joint family firm and the partnership. Particular partnership, when a partnership is formed for a particular adventure and the undertaking, or for a particular period, such partnership is called particular partnership. Such partnership automatically comes to an end on the completion of venture or an expiry of period. If the partners want to dissolve the partnership before the fixed period, it can be done by mutual consent, and if the partnership is continued after the expiry of term or the completion of venture, it's deemed to be partnership at will. Partnership distinguished from other form of business organization. Co-ownership and the partnership. If two or more persons own a property jointly and employ the same property in a business and share the profit, it is a co-ownership and not a partnership. The main point of distinguishing between the two is partnership always arises out of the contract, express or implied, whereas co-ownership may arise from an agreement or by the operation of the law or from status or any other way out. So co-hire of a property. A partner is the agent of the other partner, but in the case of co-owner, is not the agent of the other co-owners. In the case of partnership, a partnership involves sharing of profit and the losses, whereas a co-ownership does not necessarily to do so. A partner cannot transfer his right and interest to any other person without the consent of all the other partners. However, a co-owner can do so without the consent of others. A partner can only ask for share of profit out of the properties, whereas the co-owner can ask for division of property. A partner has a lien on the firm property, whereas co-owner does not. A Hindu joint family firm differ from the partnership in the following ways. A partnership arises out of the contract, and Hindu undivided family firm out the status by the birth in the family. Partnership is governed by Indian Partnership Act and HUF is by Hindu law. A minor cannot be a partner, although he may be admitted as to the benefit of the partnership, whereas in HUF, a minor is a member from the very first day of his birth by virtue of his status, but he is not a personally liable. The death of a partner dissolves the partnership, but the death of co-prisoner does not. In partnership, each partner has implied authority to borrow and bind other partners, but in HUF, firm only the karta or the manager, who is the head of the family, is entitled to do so. Every partner is personally liable for the debt of the firm, but in a HUF business, only the karta is the personally liable. A partner can demand the account of the firm, but in HUF, the member of family cannot ask for accounts. His only remedies is to ask for the partition of the assets of the business firm. Partnership firm must be registered before it can maintain suit against others, outsider, whereas the HUF no registration is required and the necessary. Every partner has a definite share and it can be changed only by agreement. But the share of co-persistent enlarge and they reduce the depending on the death of or the birth in the family. There is a definite limit to the number of partners, but there is no such limit in the case of HUF firm. Formation and the registration of partnership. Formation of partnership. Partnership comes into existence by contract, and the contract may be written or oral or implied, which is inferred from the conduct of the parties in business circumstances, according to the definition of agreement between the partners of a partnership firm. They constitute a valid contract. The parties to contract must partnership under the Indian Partnership Act 1952. There must be competent to enter into a contract. Their consent must be free. An objective should not be forbidden by the law or immoral or opposed to the public policy. However, two exceptions may be noted. A minor may be admitted to the benefit of the existing partnership firm with the consent of all other partners. As relation to partners, inter se are, that is the agency, no consideration is required to create a partnership. Partnership deed. As already stated in the agreement of the partnership may be oral, but it is always advisable to have it in a writing form so as to avoid any future disputes and misunderstandings. The written documents that contain the mutual rights and obligations of the partners is known as a partnership deed. The deed must be stamped according to the provision of the Indian Stamp Act, and copy of the same must be given to each and every partner and at the time of registration. A copy of deed should be filed with the registrar of firms. Content of partnership deed. The exact term of the partnership deed or the agreement will depend upon the circumstances, but generally a partnership deed contains the following points and the agreements points. The firm name. First of all, we have to decide a firm name, date of establishment, duration of partnership, full name and the permanent address of all the partners, and the date when each partner joined the firm. Nature and the scope of business, the place and the principal place of business of the firm, total capital, and the contribution by each and every partner. Provision for further capital and loan by partners to the firm. partners' drawings, interest on capital, loan, drawings, and current account, salaries, commission, and remuneration of the partners, profit sharing ratio of the partners, guidelines for the maintaining proper books of account, inspection and the audit, bank account and their operations, right and the duty of the partners, whether and in what circumstances notice of retirement or dissolution can be given by the partner. Provision that death or the retirement of the partner will not bring about dissolution of the partnership. Valuation of goodwill on retirement, death, dissolution, etc. The method of valuation of assets and liabilities too on retirement or the death of any partner. Provision for expulsion of a partner. Provision regarding the allocation of the business activities to be performed by individual partner. The arbitration clause for the settlement of any dispute amongst the partner. The term contained in the partnership deed may be varied with the consent of all the partners, and such consent may be expressed or implied by a course of deed. Section 11, subsection 1. Now we'll come to the registration of the partner. Registration of the partner is not mandatory in India, but registering with the document deed put into black and white all the intentions and the purpose of the partnership as well as its function. Application for the registration. The registration of the firm may be effected by any time by sending by post or delivering to the registrar the area in which any place of the business of the firm is situated and proposed to be situated. The statement in the prescribed form and accompanied by the prescribed fee stating the name of the firm, the place or the principal place of the business of the firm, the name of any other place where the firm carry on the business, the date when each partner joined the firm, the name in full and permanent address of the partner, and the duration of the firm. The statement shall be signed and verified by all the partners or their agents specially authorized in this behalf. The registrar, on being duly satisfied, record an entry to the statement in register of firm, and then issue a certificate of registration. The firm which is registered shall use the brackets and the word registered immediately after its name. If any change is made in the points, some should be duly notified to the registrar so that the same incorporate in the register of firms. Relation of partners to one another. The deed of registration drawn and agreed by the partners govern the requisite relationship among the partners. These covers the general duties of the partner. The duty to indemnify for the loss caused by fraud, the conduct of business, mutual right and the liabilities, property of the firm, profit, etc. The right of the partner. Unless otherwise agreed by the partners, the following rules apply. Right of partner in normal course. Right to participate in the conduct of the business. Section 12A. Right to be consulted. Section 12C. Right to access to books. Section 12D. Right of legal hires, representative, their duly authorized agent. Section 12E. Right to share profits, section 13b. Interest on advances, section 13d. Interest on capital, section 13c. Right to be indemnified, section 13e. Right to be used partnership property, section 15. Right of partner in some special circumstances. Right in emergency, section 21. A partner has a power to act in an emergency for protecting the firm from losses. Right to prevent admission of new partner. A new partner can be admitted only with the consent of all the partners. Therefore, dissenting partner has a right to stop admission of any new partner within the business of a firm, a partnership firm. Right to retire. A partner may retire with the consent of all the partners in accordance with the express agreement by the partners by giving notice where the partnership is at will. A right to continue as a partner. Every partner has a right to continue in the partnership and not to be expelled from firm by any majority of the partners. A right of an outgoing partner to carry on the competing business, section 36. And outgoing partners may carry on the business competing with that of the firm and he may be advertised such business. But subject to contract to the contrary, he may not use the firm name, represent himself as a carrying on the business of the firm, or solicit the custom of the person who were dealing with the firm before he ceased to be a partner. Right to share subsequent profits. Apart from rights of the partners, now we will discuss the duties of the partner. A partner may have two types of duties. Duties in the partnership contract. Partners may fix any duty. This may be expressed or implied by the course of dealing, but these duties should not violate the act or the general principle of the contract. Duties prescribed in the act. The following statutory duties are implied. Duty of good faith. Duty of indemnify for losses caused by fraud. Duties envisaged in the partnership contract. The partners may fix any kind of duties. These may be expressed or implied by the course of dealing, but these duties should not violate the act or the general principle of the act. Duties prescribed in the act. Duty of due diligence, section 12b and 13a. Duty to proper use of property. Duty to account for profit and pay to the firm. If a partner derives any kind of profit for himself from any transaction of the firm or from the use of property or the business connection of the firm name, he shall account for that profit and pay to the firm. If a partner carries on any business of the same nature as and competing with that of the firm, he shall account for and pay to the firm all profits made by him in the business. Duty not to compete. Section 16b. A partner who is guilty of the willful neglect in the conduct of the business and the firm suffered losses in consequence is bound to make compensation to the firm and to the other partners. No partners can assign or transfer his partnership interest to any other outsider or any other person. Every partner is bound to act within the scope of his actual authority. Relations of the partners to the third parties. Partners as an agent, authority of a partner. The authority of the partner means the capacity of partner to bind the firm by his act. The authority may be express or implied. Express authority and the implied authority. These are to sell firm's goods, to purchase goods for the firm or on behalf of firm, to accept any payment of debts due to firm, and to engage and discharge employees. In a trading firm, one which carries on the business of buying and the selling of goods, a partner has the following additional powers: to borrow money on the firm's credit and pledge the firm's goods for that purpose. To accept, make the issue negotiable instruments in the firm's names and employ a solicitor or attorney on behalf of firm. Reconstitution of a firm. A firm is said to be reconstituted when there is change in the composition and of the partnership. The reconstitution of the firm takes place on account of admission, death, retirement, expulsion. If partnership carries on the business other than the business for which it has been originally formed, or when the partnership business is carried on after the expiry of the term fixed for the purpose, admission of a partner. As a general rule, on an incoming partner is not liable for the debts incurred before he joined the firm as a partner. The incoming partner may, however, assume a liability for the past debts by novation. By tripartite agreement between the creditor of the firm, the partners existing at the time of death, and the incoming partner. Retirement of the partner. A partner can retire from the firm with the consent of all the other partners or in accordance with the express agreement among the partners by giving a written notice to all the partners of his intention to retire if the partnership is at will. An outgoing partner remained liable for the partnership debt contracted while he was a partner. He may, however, be discharged by novation. In the case of expulsion of the partner, a partner can be expelled only if the power of expulsion exists in the contract between the partners. The power has been exercised by the majority of the partners, and it has been exercised in good faith. In the case of death or the insolvency of a partner, the estate of the partner who dies or becomes insolvent is not liable for the partnership debt contracted after the date of the death and the insolvency. Dissolution. According to section 39, the dissolution of the partnership between all the partners of the firm is called dissolution of a firm. The law of partnership makes a distinction between the dissolution of partnership and the dissolution of a firm, where the relation between all the partners come to an end. It is a dissolution of a firm, section 39. And where there is a the end of relationship between some of the partners only, it is a dissolution of the partnership. So the dissolution of the partnership may or may not include the dissolution of a firm. But the dissolution of the firm necessarily means the dissolution of the partnership as well. Dissolution of a partnership. The dissolution of partnership takes place when even when there is no dissolution of a firm in the following circumstances. On the expiry of fixed term for which the partnership was formed, section 42A. On the completion of adventure, section 42B. On the death of partner, section 42C. On the insolvency of a partner, section 42D. And on the retirement of a partner, section 42E. The following cases, there is a necessary breaking up or end of the relationship between all the partners of the firm and the closing of business. These are by mutual agreement, by the insolvency of all the partners but one partner. The business of a firm become illegal. by notice of dissolution. Mode of dissolution of the firm, section 40 to 44. The dissolution of of partnership firm may be in any of the following ways. Dissolution without the order of court or the voluntary dissolution. It consists of following four types: dissolution by agreement, section 40; compulsory dissolution, section 41. A firm is compulsorily dissolved by the uh, educating of all the partners, or all the partners but one as the insolvent, or the happening of any event which makes it unlawful for the business of the firm to be carried on, or for the partners to carry it on in partnership. Dissolution on the happening of certain contingencies, section 42, where firm is constituted for a fixed term on the expiry of that term, where the firm is constituted to carry out one or more adventure or undertaking, then the completion thereof, by the death of the partner and by the education of the partner as an insolvent. Dissolution by notice of the partnership at will, section 43. Now, in the case of dissolution of the firm through court, as per section 44, at the suit of a partner, the court may order dissolve a firm on any of the following grounds, namely, if partner becomes of unsound mind. Next is a permanent incapacity of a partner. Misconduct of a partner affecting the business of the firm. Resistance, disregard of partnership agreement by a partner. Transfer of interest or the share by a partner. Business working in a continuous loss. Any just or equitable. After understanding the normal working and the objective and the characteristics and the importance of normal partnership, in 2008, Limited Liability Partnership Act has been introduced, and it is also known as a LLP partnership. Limited Liability Partnership Act 2008. Limited Liability Partnership LLP has been introduced in India by way of Limited Liability Partnership Bill on 12th of December 2008, passed by both the House of Parliament and sent by the President of India on 7th January 2009, and called as the Limited Liability Partnership Act 2008. It extends to the whole of India. It fundamentally changed the nature of partnership from that free and the voluntary entity of the legal one. However, the LLP Act does not harm the existence of Partnership Act. It's remained as it is, and both are independent to each other. It is basically partners' individual choice for the selection of the form of which type of partnership they can go for. Ordinary partnership, as per comes under Partnership Act 1932, or they can opt the Limited Liability Partnership Act under 2008. To understand the LLP, the Limited Liability Partnership, the definition is: the limited liability partnership means a partnership formed and registered under this Act, Section 2A. Limited liability partnership means a partnership A limited liability partnership is a body, corporate form, and incorporated under this act, and is a legal entity separate from that of its partners. A limited liability partnership shall have perpetual succession. Any change in the partners of the limited liability partnership shall not affect the existence, rights, or the liability of the limited liability partnership. The feature of LLP, body corporate. LLP is a body corporate form in the incorporate under this act. Separate legal entity. The LLP is a legal entity separate from that of its partners. Perpetual succession. Any change in the partners of the LLP shall not affect the existence, right, or the liability of the partners. Limited liability. This is the most important part. The liability of the partners is limited to their aggregate contribution in the LLP. Such contribution may be tangible or intangible, nature or both. Minimum and the maximum number of the partners. Every LLP shall have at least two partners and shall also have at least two individual as designated partners, of whom the at least one shall be resident in India. There shall be no maximum limit on the partners of LLP. Third party liabilities, unlimited to all partners. Artificial legal person. LLP is an artificial legal person because it is created by a legal process and is clothed with all right of an individual. LLP is invisible, intangible, immortal. It can be dissolved by law, but not fictitious because it really exists. Rights and the duties. Mutual rights and the duties of the partner within an LLP are governed by an agreement between the partners. Mutual agency. Every partner of LLP, for the purpose of the business of LLP, is the agent of the LLP, but not of other partners. Section 26. Partners is liable on account of the independent and unauthorized action of other partners. Thus, individual partners are shielded from joint liability created by another partner's wrongful business decision or the misconduct or any kind of fraud. Example, the professional like engineers, consultants, legal advisor, and the accounting professionals are afraid of entering into a business due to unlimited liability. Hence, the LLP Partnership Act provides an avenue for these professionals to limited liability partnership firms, which restrict their liability to the agreed amount. This has encouraged professionals to enter or form of LLPs. Management of the business. The partners in LLP are entitled to manage the business of LLP, but only the designated partners are responsible for legal compliances. Business for profit only. The essential requirement for forming LLP is carrying on a lawful business with the view to earn profit. LLP cannot be formed for charitable or non-economic purpose. Common seal. Any LLP, being an artificial person, can act through its partner and designated partners. LLP may have a common seal. If it decides to have one, thus it is not mandatory for a LLP to have a common seal. It shall remain under the custody of some responsible officials, and it shall be affixed in the presence of at least two designated partners of the LLP. Foreign LLP can become a partner in an Indian LLP firm. Section 2, subsection 1 and N. Define foreign limited liability partnership. such as a limited liability partnership form, incorporated or registered outside India, which established as place of business within India. Who can be a partner? Partner in relation to LLP means any person who becomes a partner in LLP in accordance with the LLP agreement section 5 laid down that any individual or the body corporate may be a partner in LLP provided that an individual shall not be capable of being a partner if he has found to be an unsound mind by the court of competent jurisdiction and the finding is in force. He is an undercharged insolvent or he has applied to be uh, he has applied to be adjudicating as the insolvent and his application is pending. Body corporate shall exclude. A corporation sole means a public office established by Act of Parliament or the sole office, board or cooperative society and any other body corporate not being a company as defined under Companies Act 2008-13. NBFCs are prohibited to be a partner of LLP. Following can be a partner in LLP, a company incorporated outside India. Like LLP can become a partner in another LLP. A trust cannot become a partner in LLP. However, trustees can become a partner of LLP in his individual capacity, but not in a representative capacity of any particular trust. Similarly, the HUF cannot become a partner, but the Karta can in his individual capacity, but not as a representative of HUF. Liabilities of the partners within the LLP, the nature and the extent of liability of the partners of an LLP. Every partner of LLP would be, for the purpose of the business of the LLP, an agent of the LLP, but not of the other partner. Liability of the partner shall be limited except in the case of unauthorized act, fraud, and negligence. But partner shall not be personally liable for the wrongful act or the omission of any other partner. An obligation of the part LLP, whether arising in the contract or otherwise, is solely the obligation of the LLP. The liability of the LLP shall be met out of the property of the LLP. Liability of the partner upon reduction of minimum number of members in an LLP. If at any time the number of the partners of LLP is reduced below 2 and the LLP carries on the business for more than 6 months, while the number of is so reduced, the person who is the only partner of the LLP during the time that is so carries on the business after those 6 months and has the knowledge of the fact that the carrying of the business with him alone shall be liable personally for the obligation of LLP incurred during that period. Liability of the partner by holding out. The Act provides that any person not being a partner in any LLP who by words spoken or the writing or the conduct represents himself or knowingly permits himself to be represented as a partner in the LLP, known as a partner by holding out, is liable to any person who has, on the faith of any such representation, given a credit to the LLP, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the persons who giving credit. Advantage and the disadvantage of the LLP. First of all, the advantages of the LLP. First of all, it is easy to form, less legal and procedural requirements, low cost of formation as compared to the incorporation of the companies, separate legal entity. LLP and its partners are distinct from each other. Perpetual existence. The LLP shall continue to exist till it's wound up in accordance with the provision of the relevant law. Next is limited liability of the partners. This is the one of the main advantage of having a LLP formation and partnership firm in form of LLP. The partners' liability is limited as per their contribution within the firm. Next is the flexibility in management. Under the flexibility in the management, no requirement of minimum capital contribution is there. No restriction as to maximum number of the partners. A partner cannot bind the other partners for his act, and it is easy to dissolve and wind up. No requirement to maintain statutory records except the books of accounts. After discussion or understanding the benefit and the advantage of LLP, now we can discuss some of disadvantages of the LLP. Under the disadvantages of the LLP cannot raise fund from the public. This is the one of the major disadvantage of the LLP if we compare with a company. Company can raise fund from the public, but in the case of LLP cannot raise fund from the public. It can either borrow debt from the financial institution or via a loan from the partner. These are the only two resources or the source from where LLP can generate extra fund or extra required fund. Any act of the partner without the knowledge of other partner may bind the LLP. And at the last, no separation of management from the owner. Next is the incorporation of LLP. Prerequisites for the incorporation of the LLP. Minimum two partners, individuals or the body corporates are required. Minimum two designated partner who are individuals, and at least one of them should be a resident in India. Digital signatures are required. LLP name is required. LLP agreement, drafted agreement is required. Register office and the document file through the Ministry of Corporate Affairs on a portal. LLP incorporation process, we have 7 steps. First is procure digital signature, apply for name approval, preparation of documents, file the informational form, certificate of incorporation, apply for PAN and TAN, and preparation for LLP agreement. So these are the steps, and the moment we finalize and complete all these formalities, we can form our incorporated LLP. So this is the end of today's session. Namaskar. Thank you.